I was disappointed to see last night that some of our colleagues are unwilling or unable to conduct themselves in this hearing with regular order and in accordance with the rules of the committee and the rules of the Senate. I know last night some of our colleagues even tried to cross-examine the nominee about documents but refused to let him even read them. Members of the Senate and members of Congress generally are privy to sensitive information, including classified information on occasion, and we're expected to protect that information for all of the obvious reasons. And it's inappropriate to raise these in an open session before the committee. And I think our colleagues understand that, but nevertheless decided to go ahead anyway. So I just think it's important that we remind one another that there are clear rules about the discussion of confidential material and that there can be consequences to the violations of those rules. And this idea that somehow President Bush, when his lawyer and the president decide that information represents legal advice or other protected information that was given to the president during the time he was president of the United States, and that somehow he is unable to make a claim of privilege, or that once the claim is made in consultation with his private lawyer that would be not respected by the Senate, is outrageous. And so I thought we were doing pretty well yesterday, but things went off the rails, it looks like, last night. And I hope we will return to a hearing process that respects the rules of the Senate and that treats each other, and particularly the nominee, with the civility that he and this process is entitled to. And I'd encourage our colleagues to avoid the temptation to either violate the Senate rules or to treat the witness unfairly by cross-examining him about a document and refusing to show it to him, and violating the confidentiality of some of these documents as requested by President Bush in consultation with his private lawyer.
Sir, may I respond, because it was directly invoking, may I respond, sir? No Senate rule accounts for Bill Burke's partisan review of the documents. No Senate rule and no history of the Senate accounts for what is going on right now. There was that was following this archives, this partisan operative, following his involvement in this process that I think, in my opinion, undermined the process. And the idea that we could somehow go through your lengthy process, and these documents many of these documents are dumped us in the last minute, but to Senator Cornyn actually made a very good point. I knowingly violated the rules that were put forth, and I'm told that the committee confidential rules have knowing consequences. And so, sir, I come from a long line, as all of us do as Americans, and understand what that kind of civil disobedience is, and I understand the consequences. So I am right now, before your process is finished, I'm going to release the email about racial profiling. And I understand that the penalty comes with potential ousting from the Senate. And if Senator Cornyn believes that I violated Senate rules, I openly invite and accept the consequences of my team releasing that email right now. And I'm releasing it to expose that, number one, the emails that are being withheld from the public have nothing to do with national security, nothing to jeopardize the sanctity of those ideals that I hold dear. Instead, what I'm releasing this document right now to show, sir, is that we have a process here for a person, the highest office in the land, for a lifetime appointment. We're rushing through this before me and my colleagues can even read and digest the information.
Can I ask you how long you're going to say the same thing 3 or 4 times?
No, sir.
How long do you want?
I'm saying I'm knowingly violating the rules.
Okay.
Senator Cornyn has called me out for it.
How many times are you going to tell us?
Sir, I'm saying right now that I'm releasing committee confidential documents.
Mr. Chairman, since the senator invoked my name, I insist on an opportunity to respond. I did not mention his name, but he mentioned my name, and he's right. Running for president is no excuse for violating the rules of the Senate or of the confidentiality of the documents that we are privy to. This is no different from the senator deciding to release classified information that is deemed classified by the executive branch because you happen to disagree with the classification decision. That is irresponsible and outrageous. And I hope that the senator will reconsider his decision, because no senator deserves to sit on this committee or serve in the Senate, in my view, if they decide to be a law unto themselves and willingly flout the rules of the Senate and the determination of confidentiality and classification. That is irresponsible and conduct unbecoming a senator.
I want to clarify something that I said before. There is no Senate rule that accounts for this process, period. This is not a Senate rule. I did not violate a Senate rule. But I will pause. I will pause. There is no Senate rule that I violated, because there's no Senate rule that accounts for this process. And I say to a chairman that I respect, that I believe has been fair and good to me, I will say that I did willingly violate the chair's rule on the committee confidential process. I take full responsibility for violating that, sir. And I violated it because I sincerely believe that the public deserves to know this nominee's record. In this particular case, his record on issues of race and the law. And I could not understand, and I violated this rule knowingly, why these issues should be withheld from the public. Now, I appreciate the comments of my colleagues. This is about the closest I'll probably ever have in my life to an I am Spartacus moment. My colleagues, numerous of them, said that they too accept the responsibility. There were very serious charges that were made against me by my colleague from Texas. I don't know if they were political bluster or sincere feelings. If what he said was sincere, there actually are Senate rules governing the behavior of senators. If he feels that I, and now my fellow colleagues who are with me, have violated those rules, if he is not a tempest in a teapot, but sincerely believes that, then bring the charges. Go through the Senate process to take on somebody that you said is unbecoming to be a senator. Let's go through that process, because I think the public should understand that at a moment that somebody's up for a lifetime appointment, that this issue, does the public have a right to know? This is not about the Presidential Records Act. This is not a violation of the Presidential Records Act, not a violation of Senate rules, sir. But if somebody's going to land those charges, I hope that they will follow through with me and Senator Durbin, Senator Coons, Senator Whitehouse, Senator Hirono, Senator Blumenthal, now Senator Feinstein. I hope that they will bring charges against us. And I'm ready to accept the full responsibility for what I have done, the consequences for what I have done, and I stand by the public's right to have access to this document and know this nominee's views on issues that are so profoundly important, like race and the law, torture, and other issues. Thank you.
Mr. Chairman, may I read the Senate Rule 29.5, the standing rules of the Senate, for the benefit of all senators. Any senator, officer, or employee of the Senate who shall disclose the secret or confidential business or proceedings of the Senate, including the business and proceedings of the committees, subcommittees, and offices of the Senate, shall be liable, if a senator, to suffer expulsion from the body, and if an officer or employee, to dismissal from the service of the Senate and to punishment or contempt. So I would correct the senator's statement. There is no rule. There is clearly a rule that applies.
Then apply the
Mr.
rule
Chairman.
and bring the charges.